Welcome to LexTalks, legal topics simplified, where we break down some of those tricky legal concepts and make them just a little bit easier to understand.
I think that's what we all need, right? A little simplification in the world of law.
Absolutely, especially, in a country like India where the legal system is so complex and layered. I mean, there's so many acts and sections to keep track of.
Absolutely. It can be overwhelming, especially for students just starting out.
Exactly.
Yeah.
That's who we're here for today. We're going to dive deep into a scenario that honestly can trip up even seasoned lawyers.
Oh, I agree. It's a tricky one.
So imagine this. You buy a property, everything seems legit, you're excited, ready to move in or whatever your plans are.
Right? Seems straightforward enough.
But then suddenly someone else pops up claiming they're the rightful owner.
That's never good.
And they say the person you bought it from had no right to sell it in the first place.
That's a nightmare scenario for any buyer.
It is, and it happens more often than you'd think.
Hmm.
So the question is what happens then? What does the law say about these situations?
Well, thankfully, we have a couple of tools to help us untangle these situations.
Okay, lay them on me.
We're going to explore two intertwined doctrines from the Transfer of Property Act of 1882.
Oh, the 1882 Act, that's a classic.
It is the doctrine of holding out and feeding the grant by Estoppel.
Those are some pretty hefty legal terms.
They are, but the concepts behind them are actually pretty straightforward once you break them down.
All right, so let's unpack those, starting with the doctrine of holding out. What's that all about?
So it's also sometimes called the doctrine of apparent ownership or the doctrine of ostensible owner.
Okay, a few different names, but same idea.
Think of it like this. You have someone acting as if they own the property even though they might not have the legal title.
Okay, so they're putting on a bit of a show.
You could say that, and here's the key. This happens with the consent of the real owner, even if that consent isn't explicitly given.
So it's like the real owner is turning a blind eye to what's going on.
In a way, yes. And because of that, a buyer relies on this appearance of ownership, thinks everything's on the up and up.
And then boom, they get hit with this claim from the actual owner.
That's when this doctrine steps in. It's designed to protect that buyer who acted in good faith.
So it's not enough for the real owner to just sit back and do nothing.
Not if they want to protect their rights. They have to be proactive in making it clear that they're the one in charge.
It sounds like this is all about preventing the real owner from basically pulling the rug out from under the buyer.
Exactly. It's about fairness.
Yeah.
The law recognizes that if you allow someone to act like the owner and a buyer relies on, that you can't then turn around and say, oh no, that wasn't a valid sale.
That makes sense. It's like you created this legal illusion and the buyer shouldn't be penalized for falling for it.
Precisely. There's actually a classic case that really illustrates this principle. Rem Kumar v. Queen decided way back in 1872.
Wow, 1872. That's going way back.
It is, but the principles established in that case are still relevant today. So in this case, you had a woman who was managing a property.
Okay, so she was like in charge of the day-to-day stuff.
Exactly, and the actual ownership of the property was a bit complicated, but she acted as if she had full authority to sell it.
And the real owner knew this was happening.
They did, and they didn't do anything to stop her. So she became what we call the ostensible owner through her actions and the real owner's silence.
So then she sold the property, and what happened?
The court upheld the sale even though she wasn't the legal owner on paper.
Wow, so the buyer was in the...
The court said, basically, you let her look like the owner, so you can't cry foul now.
So it's a warning to all property owners out there. You got to be vigilant. You got to make your ownership crystal clear.
Absolutely. You can't just assume everyone knows it's your property. You have to actively protect those rights.
Okay, that's a great breakdown of the doctrine of holding out. It's all about appearances at the time of the sale. But what if the seller actually gains ownership after they've already sold you the property?
That's where our second doctrine comes in, feeding the grant by estoppel.
Okay, so this one's a bit different.
It is. Imagine you buy land from someone who promises that they'll get ownership later on.
So they're selling you something they don't actually own yet.
Right. But later on, they do actually obtain the rights to that property.
Okay, so what happens then?
Well, feeding the grant is like a legal safety net that can actually make that initial sale valid, even though the seller didn't have the right to sell it at the time.
So it's like a second chance for the sale to become legitimate.
Exactly. It's all laid out in Section 43 of the Transfer of Property Act. But there's a catch. This only applies to transfers where money or something of value changed hands.
So no freebies.
No freebies. Think of it like a contract. There has to be some kind of exchange for the property.
So if I just promise my friend a piece of land, and then later on I actually get ownership of it, my friend can't just say, hey, you promised me that land, now hands it over.
Not using this doctrine because there was no consideration, no exchange of value.
So there has to be a clear bargain involved, something that shows this wasn't just a casual gift or a promise made in passing.
Exactly. That's the key difference.
Okay, so let's say I agree to buy a plot of land from you. We sign a contract. I even give you a deposit.
Sounds official.
But then it turns out you don't actually own the land yet.
Uh-oh.
But later on, you inherit that same piece of land.
Interesting scenario.
So could I then use this feeding the grant idea to enforce that original sale, even though you didn't have the right to sell it to me initially?
That's a perfect example of where feeding the grant could come into play. You paid for the property, you acted in good faith.
I even paid a deposit.
Exactly, and the law recognizes that you shouldn't be penalized just because the seller didn't have full ownership at the time the sale was made.
That seems fair, but are there any limitations to this? Like, can I wait forever to exercise this option?
There are time limits involved, and you have to act while the original contract is still in effect.
So I can't just sit on this for years and years.
No, and here's another important point. What if someone else comes along and buys that land after you inherit it?
Oh, that complicates things.
It does, because if a new buyer purchases the property in good faith without knowing about your prior agreement, they would likely have a stronger claim.
So it's like a race to the finish line. The first buyer to act after the seller gains full ownership wins.
You could see it that way. It highlights the balancing act the law has to perform. It wants to protect the original buyer who paid for the property, but it also needs to be fair to subsequent buyers who might be completely unaware of any previous agreements.
So it's all about striking that balance.
Exactly, ensuring that everyone's rights are considered.
These doctrines are fascinating. They're like puzzle pieces that fit together to create this whole picture of how the law deals with these really tricky situations.
They are, and we've only just scratched the surface.
Oh, there's more.
There's always more when it comes to law. We haven't even talked about this concept of spes successionis, which is Latin for hope of succession.
Hope of succession. That sounds interesting.
It is. It basically refers to the situation where someone promises to sell you land that they're supposed to inherit but haven't actually received yet.
So they're selling you something they only hope to own someday.
Exactly. And this is where things can get really complicated because Section 6A of the Transfer of Property Act steps in and says, hold on, you can't just sell something you merely hope to inherit.
So it throws a bit of a wrench in things.
It does, because now we have to consider how this hope of inheritance interacts with the concept of feeding the grant.
Okay. Yeah, those two ideas seem to clash a bit.
They do, but as with most things in law, there are exceptions and nuances we need to explore.
This is definitely giving me a lot to think about already, and we're just getting started.
That's the beauty of law. It's always challenging us to think critically and to consider all sides of an issue.
I'm ready to dive deeper.
Let's do it. Let's explore some more real-world examples and see how these concepts play out in practice. So, when we talk about the doctrine of holding out, there's this whole idea of the ostensible owner.
Right, the person who's like walking around acting like they own the place.
Yeah, exactly. And, they might not actually legally own the property.
Right, but they sure act like they do.
Yeah, and this often happens, like I said before, with the real owner's consent, even if it's, not directly stated.
So it's all about the impression they give to the world, right?
Right.
Like they've got the keys, maybe they're collecting rent from tenants, making repairs, doing all the things an owner would do.
Exactly. And the key here is if a reasonable person looking at the situation would believe that this person has the right to sell the property, then the law, it aims to protect any buyer who relies on that belief.
That makes sense. So it's not just about what the actual owner thinks, but about what a reasonable person would assume based on what they see.
Right. It's about protecting the buyer who's acting in good faith.
Okay, so let's go back to that Ram Kumar v. McLean case for a second. I think that really illustrates this whole sensible owner thing. Can you walk us through the specifics of that case?
Absolutely. So in that case, you had this woman, let's call her Mrs. Donald. She was managing this property.
Okay, so like a property manager.
Yeah. And the actual ownership of the property was a bit unclear, but she was acting as if she had the full authority to sell it.
And the real owner knew this was happening.
Yes, they did. And they didn't do anything to stop her, so she became the ostensible owner because of her actions and because the real owner was silent.
So she sold the property, and then what happened?
The court actually upheld the sale even though she wasn't legally the owner.
Wow, so the buyer was in the clear, even though they bought it from someone who didn't technically own it.
They were, because the court basically said, you let her act like the owner, so you can't come back later and say the sale was invalid.
That's a pretty clear message to property owners.
Yeah.
You got to be proactive, You got to make it crystal clear that you're the owner.
Absolutely. Don't just assume people know you have to actively protect your ownership rights.
Okay, so that's holding out all about appearances at the time of the sale. Now, let's switch back to feeding the grant for a minute. We talked about how this doctrine only applies if something of value changes hands. No freebies, right?
Yeah.
But what exactly counts as consideration in these kinds of situations?
So consideration is basically anything of value that's exchanged as part of a deal.
Okay, so it could be money, obviously.
Right.
But it could also be like goods or services, even a promise to do something.
Exactly. The key is that there's a bargain involved, something that shows this wasn't just a casual gift or a promise made without any real intention behind it.
So let's say I promised to help you renovate your house, and in exchange you promised to give me a piece of land. Would that count?
That could definitely count as consideration, yes.
Okay, so it's really about demonstrating that there was a clear agreement in place and that both sides were giving something up.
Exactly.
Now, let's say I agree to buy a plot of land from you. We sign a contract, I pay a deposit, everything's official.
Okay, sounds good so far.
But then it turns out you don't actually own the land yet.
Oh.
But later on, you inherit that same piece of land. So in that situation, could I use this feeding the grant doctrine to enforce that original sale, even though you didn't actually have the right to sell it to me in the beginning?
That's a perfect example of where feeding the grant could be applied. You paid for the property, you acted in good faith.
I even paid a deposit, remember?
And the law says you shouldn't be penalized just because the seller didn't have full ownership at the time of the sale.
But are there any limitations to this? Like, can I wait forever to exercise this option?
There are time limits, and the original contract has to still be in effect.
So I can't just sit on this for years and then suddenly decide to enforce it.
Right, and there's another important factor. What if someone else buys that land after you inherit it?
Okay. Yeah, that adds another layer of complexity.
If a new buyer comes along and buys the property without knowing about your prior agreement, they probably have a stronger claim.
So it's like a race to the finish line. Whoever acts first after the seller gains full ownership wins.
You could think of it that way. It shows how the law has to balance things out, protecting the original buyer, but also being fair to new buyers who might not know about any previous deals.
So it's about finding that balance between protecting everyone's rights.
Exactly.
It's amazing how these doctrines work together. You know, they anticipate these tricky situations and then provide solutions to make sure things are fair.
And we're still not done yet. Remember, we still have to talk about spes successionis.
Right, the hope of inheritance thing.
That's where things can get even more interesting because, remember, you can't just sell something you're hoping to inherit someday.
Right, the law specifically says that.
So we have to figure out how that concept interacts with feeding the grant.
Yeah, those two ideas seem to be pulling in opposite directions.
But as always, in law, there are exceptions and nuances to explore.
This is already so much to think about, and we haven't even gotten to the really complicated stuff yet.
That's what makes it so fascinating.
I'm ready for more. Are you ready to dive even deeper?
Absolutely. Let's wrap things up by connecting these concepts back to the bigger picture of property law in India and see why they're so important for law students to understand.
It's really hit home for me, as we've been talking about this, how important it is for law students in India to really get a handle on these doctrines.
Oh, absolutely.
Because this isn't just some theoretical stuff they'll forget after the exam, right?
No, not at all. Understanding the doctrine of holding out and feeding the grant by Estoppel, I mean, that's essential for any lawyer who's going to be dealing with property law here in India.
Especially because land ownership can be so tricky here.
Oh, it can be incredibly complex. Sometimes it's even unclear who actually owns a piece of property.
Exactly. So these doctrines, they provide like a framework for resolving those disputes and making sure things are fair.
Right. It's not just about passing an exam. It's about being able to apply this knowledge in real-life situations.
Because imagine you're representing a client who bought a property.
Right.
And later they find out, oh, the seller didn't actually have the full right to transfer it.
Oh, that's a tough spot to be in.
It is. And knowing these doctrines inside and out could be the difference between winning or losing that case for your client.
Absolutely. It's like having a secret weapon in their legal arsenal.
It is. And it's not just about litigation either, right?
No.
Because a lawyer who understands these concepts can give really good advice to their clients.
Right.
Help them avoid these problems before they even happen.
Exactly. It's about being proactive, preventing those legal headaches down the road.
So if you can spot the red flags early on.
Right. Like if you see signs of an ostensible owner or maybe a potential spis successionis issue.
You could save your client a lot of time, money, and stress.
Absolutely.
It sounds like to really master these doctrines, You really have to dive deep into the Transfer of Property Act and all those little details.
You do, but that's part of the challenge and the reward of being a lawyer, isn't it?
Right.
You have to delve into those complexities and then use that knowledge to help people.
And to ensure justice is done. Well, it's been really helpful to break down these concepts with you and see how they actually work in real-life situations.
Me too. I think it's important to remember, that behind all the legal jargon, there are real human stories.
Right.
These doctrines aren't just abstract rules, they're tools to resolve conflicts and protect people's rights.
They make the legal process feel a bit more human.
Absolutely. And that's what makes law so compelling.
Yeah.
It's not just about rules and regulations, it's about people and how we ensure fairness and justice for everyone.
Well said. This deep dive has given us a lot to think about. Any final thoughts for our listeners, especially those aspiring lawyers out there?
I would just encourage everyone to keep learning, keep exploring the Transfer of Property Act. I mean, it's like a treasure chest full of legal principles.
It is.
And the more you learn, the more you'll realize just how complex and how fascinating this world is.
It's a journey of discovery, for
Yeah.
sure. Well, thanks for joining us on this deep dive into the doctrine of holding out and feeding the grant by Estoppel.
It's been a pleasure.
We hope you found it helpful and insightful. Thanks for tuning in. Subscribe for more legal insights from LexTalks.